Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much, Mr. Clerk. I appreciate it. Good morning, everyone. My name is Ariane Vuno. I am an Associate Justice of the Massachusetts Appeals Court, and I'm holding this hearing in my capacity as a single justice of the court. I'm going to read the case name and number officially for the record. Case number is 21-J-404. The case name is Wilmington Savings Fund, doing business as Christiana Trust, an individual but as trustee for Premium Mortgage Acquisition Trust, which are the plaintiffs, versus Tanya Mello, Benjamin Mello, and Renee Mello. Specifically, what was before me is the defendant's appeal pursuant to General Laws 239, Section 5, from a summary process appeal bond order entered by a judge of the Housing Court on August 2, 2021. So I'm understanding here today, Attorney McGoldrick, that you represent the defendants in this case?
Your Honor, I do not. I probably should withdraw from the case. I was here. I was involved in this matter just as substitute counsel for one hearing early on in the proceedings.
I see. Okay, and you received notice of today's hearing via the clerk's office, or may I ask from any one of the defendants?
No, directly from the clerk's office.
I see. So you're still on our record as somebody to contact. I understand. Okay.
Yes, Your Honor.
So you're not representing the defendants here today on their appeal for this hearing. Is my correct?
That is correct. I was representing the plaintiff originally, so I have nothing. I never have represented the defendants in any capacity.
Oh, I understand. Okay. All right. So you're really here as a courtesy. We appreciate that, but it seems to me that you don't really have any direct involvement anymore in this case. I'm going to turn now to Attorney, is it Stower? Am I pronouncing it correctly?
Yes, Your Honor, it is.
Okay. And you represent the plaintiffs, correct?
I do, Your Honor.
All right. And are you gleaning the same understanding that I am, that Attorney McGoldrick is not really involved in today's hearing?
I am, Your Honor. I believe a while ago, like pre-COVID, Attorney McGoldrick appeared on behalf of my firm who's contracted out to appear at one of the hearings. And he's still, I'm looking at the lower court docket right now. He's definitely still there. But I think it was Attorney McGoldrick. You can obviously speak for yourself on this, but I think it was a one appearance kind of thing.
Yeah, it was.
All right.
Yes, it definitely was.
Okay, well, we don't need two attorneys representing the plaintiffs, although thank you very much. The one that's here and ready to represent the plaintiffs on this matter is Attorney Stower, so we'll leave it to him. I want to thank you, Attorney McGoldrick, for appearing, and I'm just going to suggest that when you clear this up with the lower court so that you don't continue to get notices to appear if you're not really part of the case anymore, but I leave that to you, okay?
Thank you, Your Honor. I will do that.
All right, and I think that you can be excused from this hearing. There's really it's public, of course. You may remain if you'd like to, but there's really no reason for you to participate any further.
Do you mind if I hang around just for a professional curiosity?
Well, it's a public hearing. You're absolutely welcome to be here without any problems whatsoever. All right, so let me now turn to Attorney Storer. I want to say for the record that the defendants have received notice of this hearing. And I want to be a little bit more specific about that because since they're not here and an attorney representing them is not here either, I want to say that the defendants received an initial notice that was sent by the clerk's office on August 27, and that was explained to them that their appeal had been opened and was on the docket in the appeals court. On September 2nd, a notice of today's hearing, in other words, a notice that a hearing was scheduled for September 16th at 10 o'clock in the morning, was sent to the defendant's home. On September 7th, a notice was sent again to the defendant's, excuse me, I won't say home, the address we have for the defendants on the record. At that point in time, on September 7th, the second notice was sent, which gave them the instructions for how to come to appear at this hearing on a Zoom phone call. There have been no response from either one of these two notices to the appeals court. I would like to add also that the clerk of the appeals court has left two voicemail messages for the defendants on a telephone number that was provided by the defendants and on which a voicemail message may be received. And those two messages were left on August 27 and again yesterday on September 15th, indicating that this hearing was scheduled and it was going to go forward, and that they had to provide certain information to receive their credentials and instructions on how to participate via Zoom, this remote platform that we have for hearings. So thus far, we have not heard anything, and they're not here. So what I'm going to do, Attorney Stower, is I think the best thing to do is to just suspend this hearing for a full 15 minutes or so, see if we can, if the defendants have managed to understand that they're supposed to be part of this hearing, and they can join us. I'll get back on the Zoom in 15 minutes, and we'll see whether or not we've been joined by anybody. But I do want to give them ample time to, if they're having any kind of technical difficulties this morning or something like that, I want to give them ample time to be able to participate. All right?
Sure.
Okay. So Attorney McGoldrick, I don't think that was all that interesting with respect to professional curiosity, because we're just going to suspend for 15 minutes, and there's really no reason I don't think for you to come back on. But we'll leave that to you. You can just grab, you can join the public stream at that point if you prefer. But Attorney Storer, I will see you in about 15 minutes. Okay.
Thank you, Your Honor.
Okay, thank you both very much. And clerk, thank you very much. We'll suspend the hearing and we will come back on in 15 minutes. Thank you.
Okay, I'm going to pause the recording.
That would be great. Thank you.
All right, I believe that we're still being live streamed, so
That's fine.
15 minutes.
I'm actually going to take the Zoom off of my computer for 15. I mean, I'm going to leave the meeting for 15 minutes and then come back on. Okay.
That's fine. Thank you.
Okay. Thank you. Okay, can you both hear me?
Yes, we're still on pause though for the audio, but we are live streaming still.
Okay, well, can you want to unpause us and so that this can also be heard? How's that sound?
That's perfect. I'll let you. The case is now being live streamed.
Okay, thank you very much. I'll just say for the record that we're back on our remote platform record in the case of 21-404 Wilmington Savings Fund Society versus Ms. Mello, Mr. Mello, and Ms. Mello. For the record, we called this case about 25 or 30, about 25 minutes ago. No one for the defendants appeared. We took a 15-minute break to see whether or not the defendants had any technical problems and to see whether or not they needed any aid in joining us on this platform. I just checked with the clerk's office and they have heard nothing from the defendants or anyone representing them. I'm just going to ask you, Attorney Storer, have you heard anything from the defendants or anyone that represents them with respect to today's hearing?
No, Your Honor.
Okay.
Nothing at all. They've never appeared at any hearing this calendar year, and I don't believe they've ever appeared at any point during the lower court case ever.
I did check the record, and the clerk assigned to this case has also checked the record carefully for me and as well. And it does appear that they have not to say, no pun intended, the record does demonstrate that they have not appeared in any of the other court proceedings. But as I noted earlier, they did have a notice of today's hearing. They're not here. I'm gonna conclude the hearing. Attorney Storer, thank you for your time. I'm going to get a decision on this motion out very soon, and I appreciate your time and wish you and your family well. Bye now. All right, this meeting is concluded.